you, Leslie. At this point, I'd like to just take the opportunity to respond to some of the questions and comments that were raised last week by members of the public that don't specifically relate to traffic, to valuation, to civil engineering, landscape design, just various questions that, sure.
I'm sorry.
Sure.
The easement is actually not defined in terms of its width.
I was going to get to that. Absolutely, it is not.
Okay.
That's one of the comments that was raised that you deserve an answer to. So if you would indulge me just a few minutes.
Couple of questions.
That document was provided to you so that you have a sense of what the conservation easement area is that was granted in 2007, the 5.1 acres, and the green is the half acre, 0.4 acres that is restricted by a conservation restriction. That's the only reason I provided that, so you can see graphically where those two areas are.
Do those symbols mean anything in particular?
Do the symbols mean anything?
Yeah, that was the one.
I would like that.
I don't recall what those symbols are, and frankly, if it's on here, it's too small for me to read. But we can-
appear to be wetland.
They may be wetland.
In the wetlands,
Yeah.
it's a symbol for wetlands.
Symbol for wetlands rather than having the wetland markers on the sides. In response to some of the questions raised, if you'll indulge me, first of all, you heard at length from Attorney Ainsworth. One of the things he pointed out immediately was that the utility easement is not depicted anywhere. And frankly, that's just incorrect. It's on the survey, it's on site plan, it's on the landscape plan, it's been on those plans. It was provided to him early on when he represented a group of neighbors who support this project and with whom we entered into an agreement. It's been on the plans. It was on the plans for the Connecticut Friends School. It shows a line, it shows 3 poles, it's always been there. There were comments that the easement areas are gerrymandered, they don't meet the spirit and intent of your regulation. And I'd like to call your attention to 2 plans. I'll give you them in larger version. We mentioned these in the original presentation last week, and we'll remind you of them again. These are just 2 samples of conservation developments. The bottom one is Silver Mine Avenue, the top is Harbor Bluffs. And the reason we bring them to your attention, and I have smaller versions for your review, is the top one, Harbor Bluff, which is around 2005. There was a stormwater drainage system located entirely into the conservation easement, which was reviewed by this commission and approved as acceptable. Then Silver Mine, which you've heard of tonight, there's a 20-foot wide utility easement to the First Taxing District Water Department. It's a water line that runs from north to south, bisects the entire property. It's located underground. That was part of that approval, and that was also granted by this commission. So the concept of utility easements being foreign to conservation developments are not being permitted. That's untrue. This commission has respected them, has approved them in the past. I see no reason why it can't do so in the future. Furthermore, your regulations do not specify in any way, shape, or form that conservation developments must exclude utility easements. I've given you a copy of your own regulations, and you can see that it's not mentioned anywhere. So we have to abide by the regulations as they exist, and we have done that. In response to your question, Mr. Johnson, Mr. Ainsworth first mentioned the utility easement was 80 feet wide. That's nowhere in the 1932 easement. It's not on the map. It's not in any document. Then he said it's of uncertain width. Then he said it's 30 feet wide. It's what the easement says it is. It's a N electric line, AN electric line. And it's depicted as the easement has been crafted and as the easement has existed since 1932. Mr. Attorney Ainsworth also mentioned to you that the letter from the utility company that Attorney Aceto supplied, in which counsel for the utility company was Robert Comm, am I right?
Correct, that's correct.
That you cannot consider that since it's hearsay. Well, it's established Connecticut law that you can consider hearsay testimony because you're an administrative agency. You absolutely can consider it. You can consider hearsay testimony, as you probably know, Commissioner Stern, and welcome to the commission. It is not prohibited. You are entitled to review it. It's provided all the time. Attorney Ainsworth went to great lengths to tell us that the proposal does not meet the 50%. It's shy. It's deficient. Well, you've already received I believe, from staff, a copy of a certified document from the property surveyor, from whom you must receive certification that the easement, that the overall development, that the open space meet the requirements of your regulation, and I'm going to provide to you another copy of that document for the record in case you don't have it, plus confirmation from staff that the appropriate party to establish and confirm those calculations is the land surveyor, and the land surveyor of record has done that. There were Attorney Ainsworth went to some lengths to bring you back to the 21-unit development that you had originally seen, which was submitted in December and subsequently withdrawn. I want to let you know a little bit of the history of that so that you get a better sense of what took place and how we got to where we are today. After we submitted that application, we met with various people. We met with Councilman Hempstead, Councilman O'Toole, Councilman Petrini, we met with the mayor, we met with Corporation Counsel. We discussed the project. There was a claim raised by the Corporation Counsel that we were unable to include that 5.1 acres of the conservation easement area. We disagreed with that. We provided them with our papers in support of our position. We don't waive any rights to that claim. Yet my client decided, rather than engage the courts and have the courts adjudicate the rights of the parties, he decided it would be better off, he would be more comfortable, he thought it would be a better plan to reduce the number of units from 21 to 15, and thereby provide the neighborhood with the opportunity to have 5 acres rather than just over 2 additional acres of open space. Just for your records too, and I think these were provided to staff, our correspondence back and forth, Corporation Counsel's opinion, and then our response to Corporation Counsel's opinion, which includes, by the way of background, an affidavit from Leslie Aceto, who was involved with the purchase of the property by the Connecticut Friends School and development of the 2 easements, conservation easement and the conservation restriction, as well as an affidavit from David Waters, who many of you may, whose name you may recognize. He was counsel for Connecticut Friends School, and he was involved with the creation of the easement, the conservation restriction, and the approval of the Friends School in 2006. We also then had further conversations with the mayor, with Corporation Counsel, with Councilman Hempstead, O'Toole, and Gianderco Councilman Hempstead, Councilwoman Gianderco, and Councilman Petrini, after we filed a 15-unit development. And I'm frankly surprised that after various conversations, after various meetings with those individuals, after the final conversation I had with Mr. Hempstead in June, offering to meet to provide more information, that 4 hours before the hearing last week, we're advised that they had an objection to the plan as currently constituted of 15 units, required that suggested that it be reduced to 13, and then all of a sudden, for the first time, suggested that they would prefer a 100-foot buffer. Now, I must note, that letter that came into you last week was from Councilman Hempstead and Councilwoman Gianderco, and now it was also signed off by Councilman Bonifant and Councilman Iannico. Councilman Petrini was not a signatory to that document. So for 2 months, we thought everything was fine. We'd had conversations, and then 4 hours before the meeting, that's the letter we received. Moreover, Councilman Hempstead that night not only said 13 units, he said it would even be better if we did 12 units. You heard from Mr. Lawrenson, who was a CLNP retired engineer. One of the things he mentioned, which I found very curious, so I did some research myself, was that his position was one of the concerns you should have is that vandals somehow they shoot at the transformers, so they're the ones that's a concern that you should be aware of. So with respect to that, I chatted with Deputy Chief Susan Zecca of the Norwalk Police Department, because I thought that sounds like a relatively interesting question. I didn't know anything about it, and I wanted to be sure that that was something we should be concerned about since we're proposing residential development. And for your edification, I have a copy of an email that comes from Deputy Chief Zecca. It comes from Lieutenant Paul Benet to Deputy Chief Zecca in response to my request that basically indicates that comment is unfounded. There have been no police activity reports with respect to reports of shotguns damaging the transformers. There were some reports of downed wires, fires at transformers up on Newtown Avenue, so that should just be discarded as a complete red herring and a scare tactic, in my opinion. I don't think I need to go into any more detail with respect to what Mr. Lawrenson had to say, his opinion of the easement. But one other thing he did mention was that he believed that we probably spoke to someone at Eversource who had no knowledge or understanding of the easement. Well, I think Attorney Aceto has certainly demonstrated that her conversations with Assistant Legal Counsel Robert Bourne dispels that notion in its entirety, and her letter to that effect should substantiate that. Mr. Danzer, I should say Dr. Danzer, many of the comments that he raised have been discussed and have been refuted by Kate Throckmorton, but he made some comments with respect to conservation developments, special permits, the regulations, and their consistency or lack thereof with ecologist words. When he gave you his resume, he listed all of the things he's done and all the places he's worked, and it's a very impressive resume. One thing I found interesting is he never mentioned that he was employed by the city of Norwalk in June and July of 2001 as its senior environmental officer, which is the position that Alexis Carachetti holds today. And why I bring that to your attention is Mr. Danzer's comment that the regulations aren't proper, they're deficient, or in some way don't reflect what they should reflect. It's just interesting to me in that if he was the senior environmental officer of the city of Norwalk, he would have been attending and invited to staff meetings on Friday mornings that the senior environmental officer attends today and has always attended. He would have become aware of the regulations that exist and have some passing familiarity with conservation developments and special permits. In fact, there was a conservation development that was in process during his tenure, particularly Canfield Crossing. Now, I have to admit that had no inland wetlands on it, but it was a project that was underway while he was employed in the city of Norwalk. So I'd like to think that if he thought the regulations were defective or insufficient, he would have taken that opportunity to suggest new and improved regulations that would have addressed the deficiencies that he thinks seem to exist. We've already said the width of the easement in certain areas was inadequate. Once again, your regulations do not specify the width, the dimension, or the location of the conservation easement areas. It does specify how big they need to be, 50% of the land mass. It does indicate that they can also be consistent of, they can also include previously disturbed lands. That's specified in section 410. That has been uncontroverted, and that's exactly what we're doing. The regs do not specify certain dimensions, do not require deduction of existing easements, utility easements. And as I said before, for Silvermine Avenue's conservation development, for example, it has a 20-foot wide underground utility easement crossing the center of the property and including portions of not only the conservation easement area, but the entire development area. And the zoning commission approved that project in 2010 without any question or without any issue with respect to existing utility easement. Mr. Danzer indicated that trails are not permitted in the 5.1 acre conservation easement area. And in fact, the easement that I provided to you, a copy of which, Section 3 specifically permits the use of trails or other facilities that exist or may be developed. And the conservation restriction also reserves the right of the grantor to create trails if he so desires. He claimed that the calculations were incorrect. We've double-checked the calculations. The surveyor has certified the calculations. We've provided that to you, and it's also been reviewed by staff. Comments by the engineer who Mr. Ainsworth presented to you. I believe Holton Ford did an adequate job of addressing the comments and concerns that she raised. Ms. Maddox, one of the proposed interveners, commented that she and her neighbors are very proud of saving it, and I agree with her. But it is the White Barn Preserve, which once again is the 5.1 acres. It's going to be untouched. It's not part of the calculation for density or open space. It will remain as is. So since it's going to remain as is, her desire and her need and her enthusiasm to save it is being protected. She claimed this proposal is out of harmony with the neighborhood. Well, as we mentioned to you last week, property is located in a double-A residence zone. It allows single-family residence as a permitted use. Special permit uses include conservation development, a waterfront club if this was on the waterfront, a church and church buildings, assisted living facility, a school, college, a museum, a mosque, a synagogue, a congregate housing, nursing homes. There are a variety of other uses that are allowed, some as right, some by special permit. In a AA residence zone, the minimum lot size is 21,780 square feet. This is going to be 15 houses on 10 acres. If you were to just take the math and let's just put aside the conservation issues relative to wetlands and deductions for that, if you took 10 acres, that would be 20 homes. We're proposing 15 on what is a total of 15 acres. I submit to you that this is certainly more harmonious than any of the other uses that I just indicated were permitted, whether they be by as of right or by special permit. Most recently, I believe it was 2012, this commission approved another conservation development on Chestnut Hill, which was the Fawcett development, 329, 325 Chestnut Hill Avenue. That was 12 acres. 6 acres were preserved as a conservation development, and that was for 9 units. That hasn't been built, but that was approved by this commission as well. So this development is very typical of this neighborhood. And as Leslie Aceto pointed out, Cottonwood Chase is about a half a mile to the south. Ms. Maddox went to great lengths to try to persuade you that this project violates the intent of the regulations. As I said earlier, we designed to the specifics of the regulations, and we have done so. Conservation developments in AA residence zones need 4 acres of land minimum. We have 10. They require a 40-foot setback around the entire site. We've given in excess of a 40 setback. They require a 40-foot setback from wetlands. There is an excess of 40 feet from the wetlands. More than 50% of the land is to be in a conservation easement. We didn't, as she said, quote unquote, finesse away anything. We've complied with all the requirements. Ms. Holton indicated that the asphalt parking lot can't be considered as part of the conservation easement area, and that's incorrect. Section 118.410D2 specifies that disturbed land or land not in its original condition, unquote, can be designated as conservation land, and that's exactly what's being done. It must be continuous open space and not gerrymandered. Well, the phrase gerrymandered, I think, came up with the Silver Mine development, in that there are areas that jut out. It's not a large swath. It could be areas behind developments, as you see on the Silver Mine plan. There's absolutely no support for the claim that the open space, the conservation area, first of all, can't be of the configuration that we've suggested. Conservation land must be, quote, an area within each conservation development equal to not less than 50% of the total area of the parcel. Previously disturbed land can be so designated. There's no definition of what that is. There's no requirement that it be 100 by 100. There's no definition that it be at least 125 feet long by 100 feet deep. Unlike some of your other regulations, for example, like recreation space with other developments that you have. In recreation space in a multifamily development, you have a minimum limitation on dimension. It has to be 10 feet wide. You also have a limitation that a recreation area must be at least 200 square feet. There's no such specific requirement that a conservation easement area be of a specific dimension or in a specific location. If the commission thinks that that's appropriate and that's something that you need to do, then I suggest that you amend your regulations. But we have designed a proposal, designed a project that meets the regulations, not just the spirit, but the exact wording of the regulation. So there is absolutely no such language that exists in 118.410 that requires how or where a conservation area is to be configured. You heard from Mr. Cutler, and I believe Mr. McCord addressed most of the concerns he had, and those were generally related to downstream flooding. And he also mentioned, one of the first people who mentioned that we didn't speak to him. Well, it wasn't a budding property owner. We did speak to many property owners. We spoke to the Hankins, the Calders, Mr. Diamond, and his mayor, all of whom directly abut the property to the east, all of whom were represented by Attorney Ainsworth and who are now supporters of the project and who have submitted letters of support, which I believe are part of your file. And they submitted those letters of support weeks ago. We spoke to Mr. and Mrs. Waters of Cranberry Road, who submitted a letter of support, which I believe is part of your file, and I'd like to read into the record in a minute. We also spoke to Mr. and Mrs. Mount, who are residents on Cranberry Road, and they support the project. We spoke with Mr. Moling of the Norwalk Land Trust. I'm a little surprised that when he was before you last week, he said we didn't reach out to him. Keith Rousseau, who was one of our project designers, spoke to him, and Jim Fieber spoke to him twice. So we did have conversations with the Norwalk Land Trust. Julian Henkin, one of the individuals who now supports the project, he was the former president of Save Cranberry. We spoke to Mr. Henkin when he was still president of Save Cranberry. As I mentioned before, we spoke and met with Doug Hempstead, Shannon Jandurko, Jerry Petrini, Mayor Rilling, Corporation Counsel, Mario Coppola, and Corporation Counsel Brian McCann. Furthermore, once the interveners filed their petition, I contacted Attorney Ainsworth, number one, because I was a little surprised since we had been dealing with Attorney Ainsworth in connection with some of the other neighbors that eventually supported the project, that he didn't at least extend the courtesy to say, we now have some interveners, I just wanted to give you a heads up. Well, we offered, through Attorney Ainsworth, to meet with Ms. Maddox, the Cranberry Environmental Trust, and the Norwalk Land Trust, and those offers were actually declined. We also contacted former Representative Larry Cafaro and Representative Lavielle, and they never responded to a request to meet. Mr. Pugliese was concerned about flooding, and I think his concerns have been addressed at least by Holt McCord's analysis. Mr. Welsh mentioned that he believed that there was going to be significant deforestation, and frankly, I have to admit, I believe that's an exaggeration. In response to your question, Mr. Johnson, about what trees are coming down or what trees aren't, certainly with any development, trees are going to be removed. We are not required by this commission or the Conservation Commission to do a tree inventory, but I'm not going to stand here and say that nothing's coming down. There will be. But in response to that, we're also going to be planting additional trees that Kate mentioned. There is also additional plantings proposed along the Calvert, Hankin, and Diamond properties in response to their concerns. So while there are trees that are going to be removed, I think the takeaway from this is that of the 10 acres that we're starting with to develop this project, 5 acres of that are going to remain in conservation development. Mr. Welsh keeps mentioning that the dwellings are going to be 30 feet from the conservation restriction. Now I know what he's talking about. He's right. There's a 30-foot, the houses are set off 30 feet from the edge of that easement B in green, or in yellow, whichever easement B, however I classify it. What we've been saying all along is that we must meet a 40-foot setback by zoning from the edge of the wetland line, which we meet, and we must meet the conservation requirements for upland review area and setback from the wetland, which we meet. He's talking about something else. He wants an additional setback that should perhaps have been negotiated in the easement and or the restriction. But that 30-foot doesn't exist anywhere. We must comply with a 40-foot setback in zoning from building to wetland, which we do, and we must comply with whatever the strictures are of conservation, and we do, and the Conservation Commission approved that. Ms. Coleman, who was our neighbor to the north, she was concerned about light and noise. Well, I think 15 residential developments, particularly 5 facing the pond, will have the same noise and light impact that any other residential development will have. We also have proposed dark sky fixtures, and that's in Kate Throckmorton's report, to address extensive lighting or unnecessary lighting. She also mentioned a 30-foot setback from the house to the edge of the easement. Once again, we comply with the requirements and zoning regulations and the conservation regulations with respect to setbacks from wetlands and water courses. That seems to me that that's just an attempt by some of the neighbors to harken back to 2006 and renegotiate an easement where perhaps in 2006 this should have been something that they had asked for at that point, and now we can't go back and say, well, this is what you should be doing when that's nothing anywhere remotely related to what the easement says. Many have mentioned this 100-foot riparian buffer, and that was first mentioned by Alicia Mosen, the Conservation Commissioner, Conservation staff in Westport. That is not a statute. It is not a regulation in Norwalk. It's a recommendation by DEP. And you can do whatever you'd like with a recommendation. The Conservation Commission considered that, and they believe that the setbacks from the wetlands and water courses, which are in excess of 65 feet, if I'm correct, in most instances, were more than adequate. Ms. Coleman mentioned traffic, and as Mike Belanti indicated, the levels of service will not decrease from A and B as they exist today, and that a stop sign or a lighted columbine is unnecessary. Joanne Jackson, our neighbor across the street, classified herself as a steward for the property, and she's absolutely right. And frankly, The Norwalk Land Trust has done an admirable job maintaining the 5.1 acres and keeping it in its wonderful state and maintaining that wonderful resource for the city. But they're not stewards for the rest of the 10 acres. The Norwalk Land Trust and the city have only those rights granted to them as grantees. They don't own the property next door, and as Mr. Moling incorrectly noted, they're not abutting property owners. They are grantees of an easement, and they have whatever rights that they have with respect to the language of that easement. They do not own the land next door. Ms. Jackson mentioned that there are 80 letters in opposition to this project. Well, we have 50 letters or names or signatures, and it's really not a question of how many names or how many people have signed a petition or sent you a letter. The question is, does the application comply with your requirements? And unequivocally it does. But we like to just read a few of them to you. I know you have them in your file, and I know the hour is getting late. However, here's one. This is from Joe Passero, dated August 18th. My name is Joe Passero. I'm a lifetime resident of Norwalk. I'd like to voice my support for special properties application for a 15-house community on Newtown. I believe in the idea of a conservation subdivision. The open space that will be preserved as a result of this will benefit the neighborhood and the community. I also strongly believe in the need for this type of housing to allow our empty nesters to remain in the city and generate growth for the city's tax revenue. I mentioned before that William and Colleen Waters, our neighbors across the street at 67 Cranberry, support the project. And here they say, my wife Colleen and I live at 67 Cranberry. When the initial proposal for development was 21 units, we felt this would affect the surrounding neighborhood and ecosystem in an adverse way. We were also concerned with how the proposed development would affect the water table in the area, as much of our immediate area is subject to flooding due to all the ponds and brooks in the surrounding neighborhoods. In addition, we feared usage of the south driveway, that's the driveway on Cranberry, would cause headlights to beam directly into our living room. Throughout the current review process, the FIBR group has made many concessions. The decision to close down the south driveway has pleased us very much. The reduction in the number of proposed homes is now at a level that is acceptable to us. We still fear the flooding issue, but we have come to believe that that is more of a Cranberry-Norwalk issue than a FIBR White Barn issue, as they will be implementing catch basins to control water on the White Barn property, so the risk of flooding in my backyard will be no worse than before. We will not be able to attend the meeting for August 19th, but please vote in favor. There are several other individuals that have voiced their support. And here's one other one that I think is of interest to individuals of just generally Norwalk residents who are entitled to voice their support. This is from a group of individuals signed by Nicholas Valencia, Lucia Gutierrez, Cesar Pino, Joel Sertarupa, Nelly Melendez, Robbie Tomasto, and Marlene Tomasto. It's dated August 17th. Dear Mr. Rinn and Mr. Green, we respectfully ask that you have our letter read at the public hearing so all can hear our support for the application and the reasons why. We represent a segment of Norwalk that seldom comes before your committee. We, however, are homeowners in Norwalk. We feel the burden of real estate taxes more than most citizens. We are not respectful of those. We are not respectful of those more affluent members of the Norwalk community, especially those in Cranberry who oppose reasonable development that preserve most of the natural resources. The proposed development will produce significant tax revenue for the city while not making demands on essential public services. The increased revenue will help the city in not raising real estate taxes on those of us who least afford to pay. We seldom get heard, but do not listen to those neighbors who just do not want any development near them. There are various letters that I believe these are part of your file. I just wanted to make sure that some of them were read for the record. Once again, it doesn't matter whether I have 50 and they have 80 or they have 70 and we have 60. What you have to determine is, does this application comply with section 118.410 and 118.1450? Ms. Jackson noted that she believed that the White Barn Preserve was an asset to the city, and we completely agree. My client endorsed it, supported it in 2006, and supports it and endorses it again today. And if all goes well, there'll be an additional 5 acres added to preserved land in Norwalk by virtue of this proposal. One thing Ms. Jackson mentioned, and as important, is legislation that was recently enacted by Senator Duck. I'd like to provide you a copy of the legislation. First of all, that legislation doesn't apply to this project because we haven't included the land for which public funds were used in the calculation of open space and density. So listening to that and placing any credence on the importance of that in this application is misplaced. It really is irrelevant. And by virtue of the enactment of that legislation, it would make one think that prior to its enactment, the land of that 5.1 acres could have been used toward the calculation of density and open space. Otherwise, why would the legislation need to be enacted? The most insidious thing I find about this legislation is the way in which it was enacted. It was done without research. It was done without committee meetings, any public hearing, any public comment. And worst of all, it was done without any notice to the property owner that it would affect, my client. If you read the legislation, it is so narrowly tailored, it applies to Norwalk, it applies to this property. So I find that offensive. I don't know if you do. But regardless of whether I find it offensive or not, it's located on page 609 of page 686 of the bill that was approved by the legislature just this past June. It's called a RAT, for those of you who don't know the parlance in politics, and I found that out by talking to other people. And it's called that because it's kind of slid in at the last minute. Nobody knows about it, and it's part of the larger bill, and they just vote on the budget bill, and this is the implementer, and you vote on it, and wow, voila, after you vote on it, you find out that here's an act that my client had absolutely no idea was being promulgated. I see Mr. Mushak is in the audience. I'm glad that Mike Mushak is here. I thought he was going to come to the hearing last week and praise Cape Throckmorton's landscape plan, or suggest some changes to it, or maybe even a bike path through the conservation development. But I was wrong on all three. As a former zoning commissioner, Mike Mushak should be well aware that the zoning commission, you folks, do not have architectural review capability over this project. So his comments about the houses are snout houses is misplaced. You have architectural review in very limited areas. The village districts in Norwalk and projects that are under the control and jurisdiction of the redevelopment agency. In AA resident zones and conservation developments, you do not have architectural review, so those comments should be discounted.
Special permit law allows the commission to make that determination.
Mr. Mushak, there's...
Same for the record.
There's no more comment.
Mr. Mushak did have his chance last week, and this is rebuttal and
Thank
rebuttal
you.
only. First and second of all, the regulations he claims are obsolete. Well, he was a commissioner. He was a commissioner on Silvermine. He was a commissioner with the Fawcett Conservation Development. If he thought the regulations were obsolete, he certainly could have suggested changes to the regulations to make them...
I did.
Madam Chair?
Thank you.
Maybe he made suggestions, they were never implemented. So he had the opportunity to make changes to make them less obsolete or more current. Nevertheless, the regulations are as they exist and are as they've been provided to you. Representative Lavielle noted the neighbors' concerns represent a reasonable attitude. We think the proposal is reasonable, responsible, and a sensitive design that meets zoning setbacks, that meets your conservation easement area requirements, and that meets the strictures of 410, 118, 410, and 118, 1450. What's interesting to note is Representative Lavielle also believed that the new legislation, at least as I heard her speak, should also include the half acre. The most interesting thing is she didn't vote for the implementer bill, so she did not vote for the legislation that Mr. Duff suggested. Mr. Hempstead, I mentioned before, we had discussions with Mr. Hempstead, and frankly, I'm surprised that after those discussions, he didn't deem it appropriate to give us a call and let us know that he had further concerns or questions, or that his constituents did. He waited till 3:30 last week to send you a letter, which was never sent to us, asking that you consider 13 units and a 100-foot buffer. Matt Mandel of Westport, frankly, Mr. Mandel, I've never known of a project in Norwalk that Mr. Mandel didn't have an opinion about. But we've already addressed most of the comments you've raised. I see Diane Lorichellis here in the audience, and I certainly respect her zeal, but she's not a licensed environmental professional. She's not a soil scientist, a hydrologist, a civil engineer, or a surveyor. She mentioned to you that the project does not comply with the plan of development. Once again, I have to remind you that the Plan of Conservation Development is an advisory document only. It's not binding on the commission. That is well-settled law in Connecticut. Second, consistency with the master plan is to be considered, but is not required by you when considering a special permit application. Third of all, even if it was to be considered, there are numerous sections of the Plan of Conservation and Development with which this project complies. First of all, private investment in the community, section 8.1.1, eliminating nonconformities, the nonconforming theater use that exists, that's section F.2.1.6, encouraging a balance between development and protecting the natural environment, section 8.1.1.8, encouraging landowners to establish conservation easements to protect wetlands and open space, section C.2.1.8, and there are others. But it does comply with many of the sections of the Plan of Conservation Development. To summarize, this property, as you know, is 15.4 acres. The White Barn Preserve is 5.1 acres, granted by easement, not conveyed by title, in the south end of the property and will remain. There is no plan or intention to alter it, its language, its configuration, or location. Our client agreed to this in 2007 and supports it today. That easement is silent as to inclusion of it for density or open space calculation purposes. However, the grantor did retain all rights not specifically limited or waived. If you read the easement, we've highlighted that section. Our client believes it's entitled to include this land and disagreed with the Corporation Council's position, but opted not to pursue judicial intervention to adjudicate the rights of the parties. Instead, it came back to you with a reduced plan. The conservation restriction encumbers 0.44 acres. It specifically permits inclusion of this acreage to calculate density and number of units. As a result, the land mass to be developed is 10.3 acres. The Conservation Commission, after public hearing and deliberation, approved an application regarding this development, lending its full support to it and finding that there is no credible evidence to the contrary. All municipal approvals, engineering, DPW, fire, First Taxing District Water Department, Water Pollution Control have been obtained and are in your file. As a result, we have a development that centers on just over 10 acres. The number of units are determined by a mathematical formula prepared by an engineer and certified by a surveyor, which is provided to you, and it's not a subjective calculation. You take the acreage, you divide by the minimum lot size, there's a calculation percentage that goes in, you have to take out 2/3 of the wetlands and you come up with a number. The claim of clear cutting of 2/3 of the property is just incorrect and not supported by the plans or the evidence before you. The property is in AA resident zone and will remain so. There's been no zone change application, no text amendment or variance application filed in connection with this application. Importantly, a conventional subdivision has been discussed, and it is our opinion that this would result in a less beneficial proposal for the community in the city, because you would get 0 additional conservation land. There is no requirement under Norwalk's subdivision regulations that additional land be set aside for the subdivision. So whether it's 8 lots or 10 lots or 12 lots, the number really is insignificant. The importance is with a conventional subdivision, once those lots are created, there's no more land on that property that could be conserved, and every lot could be clear-cut if that owner of that lot so desires. There's nothing in your regulations that would give you the benefit that a conservation development would give. Stormwater management system has designed to be above and beyond that which is required. It meets for the 100-year storm rather than 25. The proposal of 15 houses, 7 in the north and the 8 in the south, conserves and preserves land. It maintains and enhances the character of the property, protects the Stony Brook, the pond, and other site wetlands and watercourses. It provides more than a 40-foot setback around the property and more than 40 feet from the watercourses as required by zoning. Moreover, this proposal meets or exceeds the standards of review set forth in section 118.1450 of the regulations, which are density. As we said, mathematical formula is 15 units, and that is what we're proposing. Stable traffic flow, it's going to remain at A and B. Availability of utilities, it'll be served by city sewer and water and all of the utilities. Adverse impact from noise, dust, odor, and fumes, there won't be from a single-family residential development such as this. Signs, there is one small compliance sign proposed at the entrance of the property. Yards, open space, and buffers, 5 more acres are added to the inventory of acreage in the city of Norwalk. Impact on the neighborhood, this is a residential use, and in our opinion, it's reasonable and responsible and superior to a conventional subdivision, less intrusive than other special permit uses as we've already mentioned. It is consistent with many sections of the Plan of Development and Conservation. It conserves wetlands. 2,000 square feet of wetlands will be lost in connection with the expansion of the driveway to meet city standards, but 2,700 square feet of wetlands, which were previously impacted, will be restored, and your Conservation Commission has approved this application. Finally, no violations exist on the property. We believe the petitions for intervention fail to specifically demonstrate that this application is reasonably likely to unreasonably adversely impact the public trust in the water and other natural resources, and that you deny the petition for intervention. Conservation developments are excellent tools to balance individual property rights against environmental and other concerns of the neighborhood. They've been successfully created from Silver Mine to Rowayton in Norwalk, resulting in the preservation of over 90 acres of land, which otherwise would have been developed. This project is well designed and thoughtful. It is respectful of the unique nature of the parcel, yet allows the applicant to create a profitable development, one that all of you would be proud of. I've personally been proud to work on this project and with the professionals who have created, as I said, a well-formulated plan that is reasonable, responsible, and compliant. We ask that you give this application due consideration. We ask that you approve the application, deny the petition for intervention. But should you have any final questions of us, this will conclude our presentation on rebuttal to this evening. Thank you for your time and your attention.